The SALN laws were very clear several years ago. They only became confusing after the Supreme Court issued its own rules. Because the SALN law is really found in Republic Act 6713, as well as portions Section 7 or 8 of Republic Act 3019. If you read those laws, you will realize first that those laws are laws of general application. They apply to all public officers, whether a justice of the Supreme Court or a mere small court employee. The laws cover all civil servants, including members of the judiciary, and require not only the filing of SALNs, but access by the public. In fact, under the law, only 3 conditions are needed to release a person's SALN. Number 1, that the request for inspection is made during reasonable office hours. Second, that if the request includes copying or reproduction, that can only be done 10 days after the SALN has been filed. And third, the SALN can be pulled out after 10 years from the time it has been made available. So the law is very clear. Release of SALN is a purely ministerial act that does not require any discretion whatsoever on the part of the official or agency having custody of the SALN. So to repeat, only 4 conditions imposed by law for access to SALN. Inspection at reasonable hours, copying allowed after 10 days from filing, 10-year window, and if you will request a certified true copy, you must pay a fee. Very simple across-the-board requirements. But the Supreme Court this year issued guidelines on release of SALN that have imposed additional requirements not found in the law. And it has rebuffed attempts by citizens, some lawyers, some journalists to obtain the SALNs of Supreme Court justices. The first request did not come from the press. The first request came from a lawyer. And this lawyer wanted to have access to the SALN of the justice because he believed that there was some kind of corruption that took place in his case. The court, however, rejected his request due to a, quote, plainly discernible improper motive, which was to expose the justice to revenge for adverse decisions. But the court went even further and declared, requests for SALNs must be made under circumstances that must not endanger, diminish, or destroy the independence and objectivity of the members of the judiciary in the performance of their judicial functions, or expose them to revenge for adverse decisions, kidnapping, extortion, blackmail, or other untoward incidents. First observation I have to make about this is this was the beginning of the court's carving out of exceptions not found in the law. If you look at the law, it does not say that the government agency does not have to give the SALN if they fear kidnapping, if they fear adverse revenge for adverse decisions, and so on. These were purely additional requirements imposed by the court itself. Then next came, in 1992, a request, this time from the Ombudsman. So you have an interagency request from one government agency to the other. But again, the court denied the request for SALN. Denied because the purpose is to fish for information against certain members of the judiciary, and the court now added another requirement. If it is the Ombudsman that requests, then the request can only be signed by the Ombudsman himself or herself. A year later, a request was made not of a sitting judge, a judge who was still in the judiciary, but rather a judge who had already retired. And yet, the court denied that request and said, even retired judges are subject to the same rules on restriction of access as incumbent judges. Recent attempts have met the same fate. Malumangas is here. She knows about this because it was her organization that made the request. Since 2006, the PCIJ has asked for the SALNs of the justices, and it's been 6 years, and none have been granted. And then you have also, under former Senator Rene Sagisag, one of the authors of RA 6713, he has been requiring all of his law students to get copies of the SALNs of the justices. To date, as far as I know, none of them have been granted. So I wonder if the De La Salle College of Law will request from the Supreme Court. I wonder if our request will be granted. It's a bit sad because the impeachment trial of Chief Justice Corona opened the door to disclosure of SALN. It opened the door to a lot of things about the judiciary that the public did not know about. And those hopes of seeing more light in the judiciary were even raised higher when an announcement was made soon after the impeachment of the Chief Justice that the SALN restrictions would be dispensed with. Unfortunately, these hopes were dashed by Administrative Matter 09-8-6 issued on June 13, 2012, which now incorporate all of the conditions found in the previous resolutions of the court. First thing, without many of us realizing it, the guidelines make a ministerial act into a discretionary act. What should have been a ministerial act on the part of the custodial officer of the SALN is now a decision of the en banc of the Supreme Court. Why? Is there something to be deliberated on there or simply application of the law? The law is clear. It only has those 4 conditions to give access to the public. So what is there to deliberate about? And yet, the rules and guidelines of the court require that all applications must be decided by the court en banc. Second, that's not the only requirement. Now you have additional. All requests shall explain the requesting party's specific purpose and individual interests sought to be served, state the commitment that the SALN will only be used for the stated purpose, and must be submitted in a duly accomplished request form secured from the Supreme Court website. I don't know if many of you have seen that form. It is harder to fill up probably than a lot of government forms that you have to do. Mas mahirap pa yata sa SS yung form na yan. Plus, the guidelines of the court require that the interests of requesting individuals other than members of the media, quote unquote, should go beyond pure or mere curiosity. Additionally, if you're a member of the media, you have to have proof under oath of your media affiliation. So you have to get it signed, notarized, etc. Plus, you must obtain a similar accreditation of your organization as a legitimate media practitioner. So all of these requirements are not found in the law, but were simply added on by the court in its own set of guidelines. And finally, again, this is not found in the law, but the court now requires that anyone who applies for a SALN must have no derogatory record of having previously misused requested information. My view, the Supreme Court guidelines go beyond RA 6713 by prescribing restrictions not found in the law. The Supreme Court guidelines make it practically impossible to obtain the silence of the justices unless they themselves agree to it, and they make access to the SALNs discretionary when it should be ministerial. In fact, I have another additional point here. The rulemaking power of the court is supposed to extend to matters that are of general application. I do not believe that the rulemaking power of the court was given to them in order to create special rules for the individual members of the court. I would hope that the court would make a distinction between its rulemaking power as a court and the interests of its individual members. We must remember that even the justices of the Supreme Court are civil servants. Therefore, they must follow RA 6713. Can they make use of the rulemaking power of the court in order to change that law to impose their own additional requirements? I think there is something very problematic with doing that. I'm not sure if you have seen the disclosures, the SALN of the U.S. Supreme Court justices. When Chief Justice Roberts files his SALN, he also includes all possible conflicts of interest. Even a dinner that he attended in Harvard that was paid for by the Harvard alumni is listed in his disclosures. Why? So that any future litigant can check did this justice have any connection to this case or to any of the parties in this case? Because if so, he should inhibit himself. So SALN for judges not only provide a check on corruption, it also provides a way of determining whether a justice has a conflict of interest or not.